All rise.
Yes.
My lords, my lady, we were looking at the regulations and I'm responding to the submission that there are in some way different public interests that are represented by the different exceptions contained at regulations 12.4 and 12.5, which is a proposition that we say is incorrect, and also that there is some fundamental distinction to be drawn between the notion of weighing the public interest in maintaining the exception or exceptions against the public interest in disclosure and deciding whether the balance of the public interest favours disclosure or non-disclosure. That's the other part of my learned friend's case, that there's a fundamental distinction between those concepts. Now, we accept that that is right in this respect, as I've already made clear, that we accept that the only aspects of the public interest that can legitimately be taken into account in deciding not to disclose are those which are listed, that is an exhaustive list. But we submit that that is all that is meant in Regulation 12.1b, when the contrast is drawn between the public interest in maintaining the exception and the public interest in disclosing the information. It's simply emphasising the fact that it is only the aspects of the public interest which are envisaged and included in the exceptions that may be weighed against the public interest in disclosure. Now,
so do you say, just to catch you on yes. terminology here, if you look, as I was asking Mr. Lewis to do at the last yes. sentence of paragraph 42 in the Court of Appeal, where Lord Justice Richards refers to the overall public interest. Sorry, it's page 18 in the appendix. You see the penultimate line, the overall yes, public interest. You say, well, that's all very well. It's got to be within
specified,
the list.
Yes.
It's got to be within the list.
Yes,
you can't go beyond that.
Yes, that's right. But what I'm really doing here is addressing the point that my Lady Hale has put, is that she has said, well, how can it make a difference if you've got two exceptions engaged and neither alone is sufficient to outweigh the public interest in disclosure, then how can it make a difference if you take them together? And that's the same point that my learned friend puts. We submit it does make a difference if you take them together, and one sees this in many different contexts. And I gave the example of the public interest immunity context, the Binyan Mohammed context, that you can't say that because international relations alone doesn't outweigh the interest in disclosure, that looking at national security as well won't have that effect, or that looking at the interests of justice as well won't have that effect. If you've got three different aspects of the public interest engaged against disclosure, considering them together may make a difference. Now, I fully accept that there will be circumstances where it doesn't make a difference. And I don't suggest that you do make a simple mathematical calculation. What I do submit is that it is wrong to leave wholly out of account, when weighing the two sides of the equation, one whole aspect of the public interest which is both relevant and engaged. They must be taken into account. Now, you may conclude that when both of the public interests are taken into account, neither alone is strong enough to outweigh the interest in disclosure, and the same is true when they're taken together. But my submission is simply that the alternative solution is also a possible one, and that there is an obligation on the court or tribunal to consider it. And that what is wrong is to conduct the balancing exercise, shutting your eyes entirely, as this tribunal did, to one of the factors found to be engaged. And if the court reads back the Information Tribunal decision, what you will see is that their decision-making proceeded as follows. They said, first of all, we're looking at crime and public safety. And we find that disclosing all these details will assist criminals and could cause damage to the network and put public safety in jeopardy. But we don't think to a very great extent. And we weigh that against the public interest in disclosure, and we find it doesn't outweigh it. Then we look at intellectual property, and we find that there is an adverse effect. It affects the ability commercially to exploit. Also, they found that there was a likely adverse effect on the amount of information that will be made available. It's an ironic outcome of this case, which is in fact less environmental information is now available than was previously. But So then they said there's an adverse effect there. Then they said, when we're looking at this, we leave entirely out of account the adverse effect on crime and public safety, because that's a different exception. And in my submission, that's the error in approach. Now, I absolutely accept that they could lawfully have come to the same conclusion, taking both together. But the submission is that there's an error of approach and that the necessary weighing of the two factors together has not been undertaken.
It's a shame this wasn't a better case, really, isn't it?
In which, better for whom, my lady?
Better for you.
Well, but, my lady, of course, I want to make one thing very clear here, which is that Ofcom is the regulator. Ofcom is not seeking to prevent the public having access to environmental information. Ofcom is in a situation where it has to deal with requests for environmental information and under the Freedom of Information Act very regularly. It's therefore very important to Ofcom that it knows what is the right approach legally that it ought to adopt to those requests. And, of course, we didn't bring this appeal. Of course, we did bring the appeal to the Court of Appeal. We didn't bring this appeal to the Supreme Court. But I do want to make it clear that Ofcom is not pursuing any agenda here of concealing environmental information from the public.
Not suggesting that you were, or your clients were.
But
it's just always unfortunate
yes,
if you get a case where it's actually rather hard to imagine what difference
well, that may be so.
the different approaches on each side to the question of principle would have made to the result.
It may not have made a difference to the result. But that's why I give your ladyship the Binyan Muhammad example, because in order for my learned friend to succeed, he has to persuade the court that where different aspects of the public interest are engaged against disclosure, aggregating them can never make a difference to the overall balance. He has to go that far, because otherwise he has to confront what I say is the meaning of the end of paragraph 42 of the Court of Appeal's judgment, which is that the necessary conclusion of his argument is that there may be cases in which the public authority and the court are bound to order the disclosure of the information, even though it is against the relevant engaged public interest to do so.
Can't you get to the same result by the phrase "in all the circumstances of the case"?
Well, my lord, in my submission you can. And this is also a point that was made by the Court of Appeal at paragraph 37 of their judgment, at page 17.
Oh, the last sentence.
Yes.
The aggregate approach is also favoured by the reference in para B to all the circumstances of the case. And my lord, I would respectfully submit that that directs you to the right analysis, which is consider the factors, the relevant factors on one side, the relevant factors on the other, and conduct the overall weighing exercise.
Well, my point was that that phrase allows you to take into account headings where the public interest doesn't outweigh the interest protected, but nevertheless allows you to take it into account.
Yes, my lord, I would agree with that. Yes. Yes.
Well, I mean, the alternative is that it simply requires you, when weighing the particular interest referred to in 4 or 5, you look at all the circumstances.
But that's what's so odd.
In other words, it's neutral.
Yes.
It seems to me you can. I can't see you can get any positive conclusion from the reference to all the circumstances of the case that you're looking at other interests other than the particular one protected by a particular exception.
Well, my lord, except that it would be odd if you had a situation in which two relevant statutory interests were engaged, and you were directed to consider all the circumstances of the case, if the meaning of the draftsman was in fact that when considering the weighing exercise, there should never be a complete consideration of all the relevant circumstances together, but that there should only be separate considerations of particular factors.
Obviously, if some of the factors relevant on one were also relevant on the other, you wouldn't need to refer to the one because they come in anyway under the other. So they'd be part of the circumstances under either exception, whichever you were considering.
Well, my lord, with respect, I think that is the confusion between the overlap in the information, the overlap in the request, and the overlap in the interest. So that the request for a particular piece of information may have an adverse effect on both international relations and national security. Those are two distinct interests. It's the same information.
I see we're simply talking about something within A.
No, we're not, my lord. It's the same point applies, whether it's within A or A and B. So equally the same information.
I'm still unclear, I'm afraid, as to how you would present this following the exercise that Regulation 14 asks you to carry out. Now, this case probably isn't a very helpful example because you took the position that two exceptions did apply.
Yes.
And that's presented very neatly at pages 189 and 190.
Yes.
But let's assume that you'd not been persuaded, taking them individually, that the threshold was crossed and the presumption therefore overrode the exceptions.
Yes.
How are you going to present it? Because you can't assert, taking them individually, that either A or C is in each of them separately as a ground. So what's going to happen? You're going to say, are you going to say both exceptions apply if you accumulate them, or are you going to say, well, one of them applies because taking a little bit from A, C can be given enough weight to overcome the presumption, or what? I just don't quite see how you can actually carry out this exercise. In a way, I'm asking that question because I suspect that's what the tribunal chairmen are telling us, that they find it difficult to know how to grapple with the problem in practice.
Well, my lord, in my submission, the distinction needs to be drawn between the exception applying and the outcome of the balancing exercise being a decision that there should be no disclosure. There's a two-stage process that is envisaged. The first question is there an adverse effect on the particular interest? So the first question is, if we look at Regulation 12.5 A.
So you say yes.
Is there an adverse effect?
Yes.
Is there an adverse effect on this interest?
Yes.
And you can go through and you can identify all of the interests that you say there is an adverse effect on if this material is disclosed. So in this case, Ofcom says there is an adverse effect on public safety and there is an adverse effect on intellectual property rights.
Yes.
So those exceptions are both engaged.
Right, and you'll explain, you have to explain each one, and you will list them in your annex and say, well, these are the reasons.
Well, you'd say that this is the adverse effect. So you'd say this data belongs to the mobile operators.
Right.
We have a limited license to use it, but not a limited license to disseminate it further.
Yes.
If that material is disclosed, there is more than simply a technical infringement of intellectual property rights because their ability commercially to exploit the data is interfered with and they can't police breaches of their intellectual property rights. So there's an adverse effect on their intellectual property rights.
Yes.
And you say there's an adverse effect on public safety because the precise information about the precise location of the masts and the national network will assist criminals in theft and sabotage. So those are your adverse effects. Then you identify the public interest in favour of disclosure. And that will be, in part, the general points identified in Recital 1 of the directive, and also will depend on the particular circumstances of the case. So you identify the public interest in favour of disclosure. Then I absolutely accept that the logical way to proceed is to look at one exception against that public interest, because if you find that the first exception, that the public interest there outweighs the public interest in disclosure, that's going to be sufficient for you to decide not to disclose.
Right.
So as the Court of Appeal suggested, it will often be convenient to weigh each of the exceptions separately against the public interest in disclosure. But at that point, if you found you had more than one exception that was engaged, so you got more than one adverse effect, as the Court of Appeal said again, you need to consider the whole equation and say, well, if we take both of these questions together, national security and international relations and the effect on the fair trial, and weigh them together against the public interest in disclosure, does the public interest in maintaining those exceptions considered together outweigh the public interest in disclosure?
So as a matter of presentation, you could have a letter which is similar to what we see at page 187, with an annex in which you would list your 2 or 3 exceptions which are engaged,
Yes.
you would identify the factors that you've
Yes.
taken into account,
Yes.
and the overall conclusion would be in
Yes.
the letter,
Yes.
in which you would be able to say, picking up Lord Collins's point, in all the circumstances of the case,
Yes.
we withhold the
Yes.
information. Is that a way in which it could be done on
It
your
could, my lord,
argument?
You have to list all the exceptions.
Only those that you found
Yes, which
were
are relevant.
engaged. But that's,
Yes.
that's the position anyway.
Well, that sets the parameters for review when it goes to the Commissioner,
Yes,
obviously.
of course, other parties may seek to bring in other exceptions. What may happen is that,
Yes.
as in this case, you have a private operator, T-Mobile, who says, actually, there is a much more severe impact on crime than Ofcom appreciates, and we're the people with the evidence, and they showed that to the
Yes.
tribunal.
Well, you cover
So-
yourself in the last sentence of the letter by saying there may be other exceptions which
Well,
apply other than
yes.
those listed. Which,
But
Is it a complete
however you do that-
rehearing, the appeal? Is it a complete?
I think it's error of law, my lady. Is that right, is it?
No, they
No,
heard
the-
evidence.
No, sorry. The tribunal is a complete rehearing, the Court of
Yes.
Appeal is error.
That's what I thought. So
That
the
oral
tribunal looks at the
evidence-
whole thing again.
It is a complete rehearing
De novo,
and
yes.
oral evidence and cross-examination.
Yes.
right, so fresh exceptions could be brought in at that stage.
Indeed, and indeed were in this case.
Yeah.
Because the history is that Ofcom relied on the prevention of crime exception. Then after the Information Commissioner found that that wasn't engaged, Ofcom didn't pursue that exception, only pursued intellectual property, and then T-Mobile pursued that exception.
Yeah.
So you're saying,
The point's made that fresh exceptions can be brought in at the discretion of the tribunal.
you're saying basically there are three stages. Identify each of your protected
Engaged
interests, we might
yes.
call them, that are engaged. Then identify the various factors relating to the public interest in disclosure,
Yes,
which may be both general and particular.
yes.
Actually, it's 4 stages. And then ask yourself whether those outweigh
Individually. Because if they do, that's the end of it.
And then stand back and look at the big picture
look
and
at the bigger
say,
picture.
because we've got more than one factor, does that
Yes.
tilt the balance in
That's
some
right.
way? So it's
That's
4 stages, I think, in
That's
the
right,
end.
my lady. And we submit that if, on my learned friend's analysis, he has to persuade the court that there is no situation in which stage 4 could produce a different result from stage 3.
You may not reach stage 4 because you've already got there
Absolutely,
one of the earliest
yes,
stages,
absolutely.
but it's in the
Yes.
example where
Yes.
you haven't
That's right.
reached that, but you
That's
may be
right.
quite close to the margin.
That's right.
You say you can't
You
can't
can't
rule out
say-
forever that there may not be an overlap.
That's right. You can't say that there's no situation in which the fact in which there is a separate adverse effect on the public interest won't alter the balance. And my learned friend either has to say that that can never be the case, or if he accepts that it can be the case, he has to put forward to this court the proposition that it was the intention of the legislator that there should be an obligation to disclose information even when it is against the identified and defined public interest to do so. And we submit that cannot be the intention of the legislation.
The public interest in disclosure in any particular case is a constant, isn't it? You work out what it is. I mean, it may be the basic general public interest in the disclosure of environmental information, or it may be that plus particular aspects that make it particularly important in the given case.
In the given case.
But once you've got there, you've got
Yes.
a constant
Yes,
against which, or as I understand your case, you've got to measure the public interest going the other way.
yes,
And if I understand your case, in order to measure the public interest underway, you must look at all the aspects of that public interest,
Yes.
because otherwise you are not comparing like with like.
yes,
Or turn it the other way around, as I was suggesting before lunch, that if you do them separately, and I can see why you do them separately,
yes,
you will be double counting your constant
Yes.
if you separate them out.
Yes.
But you've only got one constant, and it's illogical to double count it for the purpose of saying, well, in case 1, the exception is 95% or nearly as good as the public interest in disclosure. Exception 2 again, is nearly to 85%, but looked at individually, neither of them comes up to the value of the public interest in disclosure.
Yes.
But together, they overwhelm it.
Yes, yes, my lord. And we submit that to take that approach would be radically different from the approach which is normally adopted in public law decision-making, which is to look overall at the interests which are identified as being relevant and to weigh them against each other. And I've given the analogy of public interest immunity. Can I just show your lordships quickly one case on PII, which is the Wiley case.
Can I just ask you to address one point? I mean, you've been tending to talk about, or people have, the public interest in withholding.
Yes.
But some of these factors are public interest factors, but certainly not all of them. A and B are, but C is private interest. D is sort of mixed, perhaps. E is a private interest. F is a private interest. And G is a public interest. So, I mean, there isn't any... these are different interests, and not all of them are public.
But can that be so? Because you've got to weigh the public interest in maintaining the exception. Surely there can't have been any point in putting an exception in which doesn't have any public interest.
Yes, my lord, this is
and
a slight oddity.
Is there not a public interest that the law of the land protects intellectual property rights, and the public has an interest in upholding the law?
This is the slight oddity in the difference between the drafting of the regulations and the drafting of the directive. I'm going to come to the directive in a minute, but as your lordships will recall, the directive talks about the interest served by refusal. It doesn't talk about the public interest. The public interest comes into the regulations, and that leaves one with the oddity between the positions that your lordships have both just put to me, that at first sight, some of these appear to be private interests, and yet the legislator must envisage that there's a public interest or they wouldn't be included on the list. And in my submission, the only way that that circle can be squared is on the reasoning that Lord Savile has just put forward, which is that it is taken to be the intention of the legislature that there is a public interest in maintaining intellectual property. And that makes sense when one considers, for example, Article 1 of the First Protocol, that people's intellectual property rights are rights to which they, of course, have a fundamental right under the Convention and therefore that deserve protection. Now, one can go through the individual exceptions. Luckily, this is not an issue that we have to be concerned with now, because we start from the assumption that there is a public interest in maintaining these exceptions, or they couldn't be on the list if these were purely regarded as private interests.
Well, I mean, quite a good example at page 190. I'm sorry to go back to your letter, but it's very revealing, because in dealing with C, which at first sight seems to be in private interests, intellectual property rights.
Absolutely.
You make the point that actually, looking at the reasons, it is in the public interest not to disclose the data set. That would mean that mobile operators would be unlikely to provide the information.
Yes.
So, I mean, there's a public interest in their being prepared to provide you with information. They do so in the knowledge that there is a system which enables their interest to be protected.
Yes.
And you want to preserve that system, and that's the public interest element in it.
And one can see the same point if you take, for example, the interests of people at F who provide information voluntarily.
Yes.
One can see how that same point would apply with considerable force in that situation.
So, I mean, there you have a definite public element, public interest element, and you're weighing that up against the general public rule of public disclosure, and you're saying, well, actually, in this case, it's rather important, given the precision that's being looked for, to maintain the exception.
Yes.
I mean, I think that's the way your reasoning goes, as expressed in
can I just show you
And F, for example, could have Article 6 of the Human Rights Convention in mind, the right to respect for privacy.
Article 8.
I beg your pardon?
Article 8. The right to respect for privacy.
I'm sorry, I always get the article numbers wrong. You're quite right, yes.
Yes.
In the sense that is a public right.
Absolutely. And of course, the same is true of property rights under the Convention.
Yes.
Can I just come... I've been drawing an analogy with public interest immunity, and if I can just take the court to the Wiley case, which is at tab 14 of the second authorities bundle. This is simply to deal with the submission that was made by the appellant that each of the exceptions is to be treated as if it were a separate public interest, to be weighed against the public interest in disclosure. We submit that is conceptually incorrect. I'm going to come back to the regulations in a moment, and the court will see that the public interest is always seen as a single indivisible notion. And of course, we've seen already at Regulation 12.6 that it is distinguished in that way from the particular interests referred to in Regulation 12.5. But if we go to Wiley at page 298, just below the letter D, Lord Woolf, all of the other members agreed with Lord Woolf's reasoning. He's talking here about waiver and that the public interest immunity privilege cannot be waived. He was referring to the situation after it being determined that the public interest against disclosure outweighed that of disclosure in the interests of the administration of justice. When that is the determination which has been made, it's inevitable that the preservation of the document should follow so as to protect what had been held to be the dominant public interest. It is, however, unhelpful to talk of waiver in the different situations where the balancing of the conflicting public interests has not yet been carried out, or where it's been carried out and the result requires disclosure. Although it is the practice to talk of conflicting public interests, this can be misleading. The conflict is more accurately described as being between two different aspects of the public interest. If it is decided that the aspect of the public interest which reflects the requirements of the administration of justice outweighs the aspect of the interest which is against disclosure, then it is the public interest which requires disclosure. And we would submit that that basic principle applies also when one is considering what is meant by the public interest under these regulations. That we don't have lots of little different separate public interests. There's an overall public interest which has got to be assessed by weighing competing aspects of it. Now, can I just come to two further provisions in the regulations themselves which we submit support our approach? We go back to the regulations in tab 1 of Authorities Bundle 1. And I'd like to come to Regulation 15. This is dealing with a situation where you have a PII certificate in the context of environmental information. So Regulation 15.1. A Minister of the Crown may certify that a refusal to disclose information under Regulation 12.1 is because the disclosure, A, would adversely affect national security, and B, would not be in the public interest under Regulation 12.1b. And we're then told that that certificate is determinative. But what I draw the court's attention to is the wording of 15.1b, that the question for the minister is whether disclosure would not be in the public interest under Regulation 12.1b. And in my submission, that's a powerful indication that the exercise of considering whether the maintenance, the public interest in maintaining the exceptions outweighs the public interest in disclosure is regarded as the same as the question whether disclosure would be in the public interest. There's no difference. And we see the same point.
Sorry, I don't understand the point.
Yes.
This relates exclusively to national security, doesn't it?
Yes, but it refers back to 12.1b, my lord.
Well, so suppose can he certify that it would affect national security, but might not be in the public interest if matters were taken into account which related to matters other than the public security, national security.
Well, this is dealing particularly with a national security certificate. But the point that I make is that the wording at 15.1b is referring back to the exercise that's done at 12.1b.
Yes.
Yeah.
And the question that's being asked is whether disclosure would not be in the public interest under Regulation 12.1b. And I submit
because in maintaining the exception,
You
which
can
is
read it
national
either
security.
way.
Yes, well, I'm going to show your lordships and your ladyship another example. But the reason I make that point is that there's considerable stress made by the appellants on the wording in 12.1b, the public interest in maintaining the exception, and the suggestion that that means something different from weighing the public interest against disclosure against the public interest in favour. Now, I submit this is an indication that it doesn't mean something different. We get a stronger indication if we look at Regulation 17. Now, Regulation 17 deals with historical and transferred public records. Transferred public records, this is a phrase that actually comes from the Freedom of Information Act. If the court goes to Regulation 2, you'll see that they're defined by reference to Section 15.4 of the Freedom of Information Act. And that section simply says that they're records that have been transferred either to the Public Record Office or the Lord Chancellor or the Northern Irish Public Record Office. So if we look at 17.1, where a request relates to information contained in a historical record, other than one to which paragraph 2 applies, and the public authority considers that it may be in the public interest to refuse to disclose that information under Regulation 12.1b, the public authority shall consult various people before it decides whether the information may or may not be disclosed. And I submit that that's another indication that the regulations here are envisaging that the exercise that is to be done under 12.1b is an evaluation of whether disclosure is or is not in the public interest. And we see the same thing again in my submission when we look at Regulations 17.2 and 17.3. 17.2 is transferred public records. And what we're told here is the appropriate records authority shall consult the responsible authority on whether there may be an exception to disclosure of that information under Regulation 12.5. If the appropriate records authority decides that such an exception applies, subject to paragraph 4, a determination on whether it may be in the public interest to refuse to disclose that information under Regulation 12.1b shall be made by the responsible authority. So again, in my submission, what one sees in Regulations 15, 17.1 and 17.3, by explicit reference to Regulation 12.1b in each case, is that what these regulations envisage the exercise under 12.1b as being is a determination whether disclosure is not in the public interest. And we submit that supports our submission that you have to evaluate the whole of the public interest on both sides and then decide which is predominant.
But I think you said earlier,
yes,
and I'd be quite sure that you maintain this, that in looking at that question, you're confined within the list.
Of course.
In 12.
Yes, and the reason for that
12,
is that, as I've said before, we absolutely accept that this is a narrow and restrictive regime.
Yes.
Where the presumption is in favour of disclosure, and that one of its features is that there is an exhaustive list of potentially relevant public interests against disclosure.
Yeah.
And that's the key safeguard that we submit maintains the policy of safeguarding the right of access to environmental information. That you can't say there's another public interest that's not mentioned in the list and we're relying on that against disclosure. And that we submit is the significance of the wording at 12.1b, public interest in maintaining the exception.
But isn't it?
That's the significance of that phrase.
I mean, isn't 17.3 rather difficult to reconcile with your submission because it postulates a two-stage process? The appropriate records authority must first decide whether an exception applies, and then if it does, the public interest decision is made by the responsible authority. Now, there's no provision for what you say can happen, which is that none of the exceptions applies, but nonetheless the public interest makes them all apply.
No, my Lord, with respect, my submission only comes into effect where where more than one of the exceptions applies. This is the distinction I was drawing before between an exception applying
Yes, I see.
and the public interest outweighing the public interest in disclosure. Because in order for the exception to apply, it has to be determined that there is an adverse effect on one of the engaged interests, one of the specified interests. Then the exception applies.
Yes.
Then you do the weighing.
So they're all in play because they're all.
Well, they're only in play if they're found to apply.
Well, of course, but I mean, they're all in play if you say that they would adversely affect.
Yes, only if they apply. Yes. So the threshold question is there an adverse effect?
Yes.
That means the exception or exceptions, that's my singular plural point, apply, and then you weigh the public interest as a whole. So we submit that Regulation 17.3 strongly supports our submission, because it envisages a single exercise, a single decision, an overall weighing of the public interest against disclosure, subject to the defined list.
Yes.
Now, the appellants seek to rely on Regulation 13.3, which they say supports them. This is an exception dealing with personal data, which is, of course, principally dealt with under the Data Protection Act.
Sorry, where are we going to? I beg your pardon.
Regulation 13, my Lord. And they rely in particular on Regulation 13.3, where it said that by virtue of any provision of Part 4 of the Data Protection Act, the information is exempt from Section 7.1 of that Act, and in all the circumstances of the case, the public interest in not disclosing the information outweighs the public interest in disclosing it. And the appellants have argued in their printed case that that wording, the public interest in not disclosing the information outweighs the public interest in disclosing it, is to be contrasted, they say, with the wording of Regulation 12.1b, and they say it supports their argument that there should be no aggregation. Now, we say that completely misses the point. The point is that under the Data Protection Act provisions, there is not the same restricted list of permissible public interest factors that there is under this regime. So there is a general question of balancing the public interest against and the public interest in favour. This regime only permits one or more of the specified exceptions to be relied upon, but we know that there is no intention to have a fundamentally different approach to 12.1b from that which is here at 13.3, because the wording at 17.3 and 17.1 and 15.1b is strikingly similar to the wording at 13.3, with explicit reference to 12.1b. So what is different about 12.1b is that you can only take into account one of the listed factors, but what is not different is that you consider all engaged factors, all exceptions that apply, together. Can I now come to the directive? Because in my submission, the construction that we've applied to the regulations, it accords with the natural meaning of the regulations and also with the policy. And your lordships have my submission about the undesirable consequences, if I'm wrong. And we submit that there is nothing in the directive that requires a contrary result. Indeed, our submission is that to the extent that the directive sheds light on this question, which is somewhat limited, it favours our construction. So if we now turn to the directive, which is in tab 5, my learned friend showed the court the provisions in the recitals that stress the importance of the right of access to environmental information, and we certainly don't seek to dissent from any of that. We do make the point, however, that it is not an absolute right. Self-evidently not, because there are exceptions, and one also sees at Article 1 that the objectives of the directive are to guarantee the right of access to environmental information held by public authorities and to set out the basic terms and conditions of its exercise. My learned friend relied on recital 16, which is to be read together with Article 4.2 of the directive. And in my submission, there is nothing in either of those provisions that tells against my construction. Indeed, my submission is going to be that 4.2, in fact, strongly supports my construction. If we look at 4.2 first, because that's the dominant provision, and my submission is going to be that recital 16 really echoes it. So at Article 4, we have the exceptions set out at 4.1 and 4.2. And my learned friend makes an argument, both in relation to the directive and in relation to the regulations, which mirror the directive in this respect. He says that the exceptions at 4.1 or at Regulation 12.4 are qualitatively different from the exceptions at 4.2 or 12.5, and that shows you can't aggregate. Now, there are two answers to that. One is the answer that my Lord Mance gave, which is that if you can't aggregate between 4.1 and 4.2, it doesn't follow that you can't aggregate between the paragraphs of 4.2. Second point we submit is that in any event, there is nothing about the nature of these exceptions which would make it unfeasible or impractical to aggregate in any event. Now, it's true that there is something slightly odd about the notion, if we look at Article 4.1b, that a request is manifestly unreasonable and yet still the public interest favours disclosure. And that, in my submission, is what's slightly odd about this statutory scheme. It's nothing to do with aggregation. It's the idea that you still do the public interest balancing exercise when you're faced with a manifestly unreasonable request. Now, that shows how strong the right is of access to environmental information. It has nothing to do with the question of aggregation or not aggregation. And we give an example in our printed case of a situation where you might have exceptions engaged under 4.1 and under 4.2. For example, the person who asks for disclosure of all the commercially confidential information about mobile phone masts that's ever been submitted by any of the mobile operators to Ofcom ever since Ofcom came into existence. And you could say, well, that's a manifestly unreasonable request, and it interferes with a number of the Article 4.2 rights, including intellectual property, confidentiality, and so on. And in our submission, there is nothing in principle that would stop you considering those different aspects of the public interest together and weighing them against the public interest in disclosure. Now, it may be that there won't be many cases where you have to do that, because it may be that if you start from the proposition that you've concluded that a request is manifestly unreasonable, it's not going to be very difficult for you to conclude, just looking at that the public interest does not favour disclosure.
Am I right in thinking, sorry, I'm just worrying about this.
Yes.
The Article 4.1
yes.
does not, except in 4.1e, require any balancing act.
Well, my lady, it does. It does require a balancing act in relation to all of the paragraphs. Because if you go to 4.2, the crucial passage...
it refers to both paragraph 1
paragraph 1 and 2, yes.
I suspect, I mean, it's quite possible this was an error.
It is possible.
Because
it's not in the Aarhus Convention.
It's not in Aarhus, it's not in the first Commission proposal.
Yes.
So it was probably proposed by somebody and no one objected, just have an easy life.
Yes. But that's what... well, my lord, that's all... This is always the subtext of a directive, that when we sit here anxiously trying... It's a bit like biblical exegesis. It's all got to be perfect in the best of all possible worlds. And your lordship may be right. But, of course, what's odd about 4.1 is nothing to do with the aggregation. It's the oddity that you balance at all. So we submit it's neutral on the question that...
Well, especially as it's expressly referred to in E,
yes.
But not in any of the
Absolutely,
others.
my lady. Absolutely, my lady. And we'll look at Aarhus in a moment, and it is an oddity. But the crucial passage, so we submit that takes my learned friend nowhere, either for the directive or where he makes exactly the same point in relation to the regulations. But then if we come to the passage on which he most strongly relies, we submit this passage actually supports us. The grounds for refusal mentioned in paragraphs 1 and 2 shall be interpreted in a restrictive way, taking into account for the particular case the public interest served by disclosure. Now that makes it clear that you have to assess the public interest for in favour of disclosing the information on the facts of the individual particular case. Then, in every particular case, the public interest served by disclosure shall be weighed against the interest served by the refusal. Now, we draw attention to the distinction in this paragraph between the grounds for refusal that are referred to at the beginning of the paragraph and the interest served by the refusal. We submit that what you can see in this paragraph is that it envisages a single request for information, i.e. a particular case. The particular case is the particular request for disclosure of information. In that particular case, grounds for refusal may be relied upon, and those are the grounds that are listed in paragraphs 1 and 2. Then you have to assess the public interest served by disclosure, and then you have to weigh that against the interest served by the refusal, not by each individual ground for refusal, but by the refusal considered as a whole. And we submit that therefore, where the refusal is on the basis of more than one ground, you weigh those grounds together against the particular interest served by disclosure. And that on my learned friend's case, what you would expect to see in this paragraph is not the phrase, the interest served by the refusal, but the interest served by each particular ground of refusal relied upon. So that's the first point that we rely upon here, where we say that, in fact, the directive tells against my learned friend's construction.
This whole sentence is really a guide to interpretation of the grounds for refusal, isn't it? I mean, you look at the beginning of the sentence, that's what you're doing here.
That they must be interpreted, yes.
And you do have to take them one by one, I suppose, to carry out the exercise.
Yes. But then you weigh the interest served by the refusal, not the interest served by each ground. You weigh the interest served by the refusal. The key point that's being made here is that there shall be no class claims. My submission, that's what this is really getting at. That's the key point. But it's saying you cannot have a situation where a state says, we will not disclose any information that adversely affects intellectual property rights, blanket ban. It's making it very clear that you've got to conduct the weighing exercise on the grounds, on the particular facts of an individual case. The individual grounds are to be restrictively construed. There's always got to be a weighing. But then in my submission, it's you weigh the interest served by the refusal as a whole against the public interest served by disclosure.
Mr. Lewis was right in saying that one doesn't normally get much help from the Travo, but to the extent they are some help, they do help you because at various stages in the formulation of the directive, there were phrases such as public interest served by disclosure outweighs an interest protected by an exception, or the specific interest protected by non-disclosure. Yes. And those didn't find their way into the final document.
Yes, well, we had looked at the Travo and we had come to the conclusion that they weren't sufficiently clear either way to be of much assistance, but I do take your Lordship's point.
And you didn't want to draw our attention to how unclear they were in case we fancied making a reference.
Well, my lady, ultimately one is looking at the legislation and the court will make its own view clear. But in my submission, there isn't really any lack of clarity here when one understands just how unusual the approach that the appellants are seeking to put forward actually is, and how different it is from the approach adopted in almost any other context where you have a right exercisable subject to qualification or condition. I cannot think of another context in which you would apply this approach to the weighing of competing considerations for determining whether a right should or should not be interfered with.
Yes, and that may be why the Court of Appeal agreed with you.
Well, my
Because
lady,
they're more used to all the other contexts.
well, but my lady,
And the
certainly,
specialist tribunal doesn't agree with you because it's more used to this context.
well, my lady, it's certainly true that the Court of Appeal contains some very eminent public lawyers, and indeed eminent European lawyers who are very used to dealing with the European context. Now, the Information Tribunal is, of course, expert in dealing with requests for freedom of information, but with great respect to them, not necessarily so expert in the interpretation of European law or public law principles. It's a question of what you mean by...
They're putting it all into practice, you see. They're looking at it, how do we actually do this intellectual exercise? Are you asking us to do an intellectual exercise which, in the reality of the cases that we have, is meaningful? That's what they're asking themselves. I don't know what the answer is, but that's what they're definitely asking themselves.
But, my lady, how is that, with respect, how is that exercise significantly different from the exercise that a court has to apply when considering a claim for public interest immunity? Of course, the context is different.
It is.
Of course, the context is different, but the exercise, in my submission, is not fundamentally different because you're considering the same question, balancing the public interest factors in favour of disclosure and against disclosure. Yes, you have a broader discretion as to what public interest factors can be taken into account against disclosure. But in my submission, it would never be suggested that when conducting that balancing exercise, the court was required to take each public interest factor relied on by the state and balance it separately against the public interest in disclosure. And we submit that if such a strange approach, which precluded an overall balancing exercise, was to be mandated by this legislation, you would expect to see some indication in the text that that was what was required, because it departs so radically from the normal methods of decision-making. But one doesn't see it. I'm going to turn to the Bovis case in a moment, but my lady, you know, in my submission, one can perhaps place a little bit too much weight on the irritation of a tribunal with being overruled. And, you know...
Well, in the end of the day, they've got to take the interpretation
of
the regulation from us, but it is quite noticeable that they're finding it difficult to grasp, and so
well, one tribunal has said
we do need to give them further guidance, don't we, if we're to be with you.
I absolutely agree, Will, that it would be of assistance for everybody, and Ofcom is here because we were required to be here because the Commissioner appealed, but Ofcom has throughout been seeking further guidance.
One of the questions that it may be a complete red herring, or it may not. But the same wording is, I think, sitting there in the Freedom of Information Act.
Yes, well, certainly similar wording.
Yes. Well, in Section 2, subsection 2 of the Freedom of Information Act.
Yes.
And one of the points made at some stage in the course of this litigation was, well, this is what we do under the Freedom of Information Act. And we're used to that exercise under the Freedom of Information Act when we're applying Section 2, subsection 2. And of course, the Freedom of Information Act is not the result of the European directive. But clearly, the draftsman of the regulations thought it'd be a good idea if the Information Commissioner and the Information Tribunal were adopting a similar approach between the two. If we interpret these regulations, either way,
yes,
this is a neutral
it's
point.
likely that it will apply
It
to
is
the
likely that
other
it will affect
yes.
the Freedom of Information Act too.
I accept that, yes, my lady.
Yeah.
And of course, I would make exactly the same submissions about the Freedom of Information Act that I make about the EIR.
Well, the phrase in 12(1)(b) really is, as pointed out, is exactly the same.
Yeah. Except that the FOIA uses the word exemption instead of exception. But I don't suggest that there would be a difference of approach under FOIA. Now, so I've drawn attention...
The same problem couldn't, legal problem doesn't arise under that Act, does it? Because of the combination between 2.2 and 31 and 30. Under this Act, there's no doubt that you look at the matter in the round, is there?
Well, actually, my lord, before our case was decided, it was the practice of the tribunal to look at individual exemptions under FOIA and not to aggregate.
Yes.
Subsequent to the Court of Appeal decision in this case, they have taken the same approach under FOIA that they take under the EIR. You have in the bundle, as a matter of fact, an extract from Philip Coppell's textbook on freedom of information. It's at tab 19, where he expressed his view about the correct approach under FOIA. Page 551. Yes, that's right. It's in the middle of the page. Where information is rendered exempt information by more than one qualified exemption, it would seem that the public interest in maintaining the exemption must be balanced one exemption at a time against the public interest in disclosure. And that's a passage that the Court of Appeal, in their judgment, said they thought was not correct. Now, I was drawing attention to features in the directive that we say supports our interpretation, and I've dealt with the key passage at Article 4.2. Now, Article 4.2 echoes and enacts Recital 16, and in my submission there is nothing in Recital 16 which detracts from the interpretation I've placed on 4.2. We go back to Recital 16. The right to information means that the disclosure of information should be the general rule, and that public authorities should be permitted to refuse a request for environmental information in specific and clearly defined cases. Grounds for refusal should be interpreted in a restrictive way. So, specific and clearly defined cases is clearly a reference to the exhaustive list. But then grounds for refusal should be interpreted in a restrictive way. That's the passage in 4 we've just been looking at, whereby the public interest served by disclosure should be weighed against the interest served by the refusal. Same formula that we have in 4.2. The reasons for a refusal should be provided to the applicant within the time limit laid down in this directive. So again, we submit takes the matter no further than 4.2 does. And the final point that we make is a point I've already made in relation to the regulations, which is the organisation of the paragraphs under under Article 4.2. where you have some different aspects of the public interest grouped together in a single subparagraph, and others dealt with separately. And you have some closely related interests in separate subparagraphs and some in the same subparagraph. And in my submission, it is impossible to discern any policy or principle for dealing with them in that way, and that strongly suggests that there was no intention under the directive, or we would submit under the regulations, that their inclusion in a single or separate paragraph should affect the way that they were weighed against the public interest in favour of disclosure. Can I now turn to the Aarhus Convention? Because again, we submit that this takes the matter no further. It supports the general policy about which, of course, we have no quarrel. And the key passage is Article 4, access to environmental information. And the passage that we are concerned with in particular is at the top of, these pages are not numbered, but at the top of the page just before paragraph Article 4.5, the aforementioned grounds for refusal shall be interpreted in a restrictive way, taking into account the public interest served by disclosure and taking into account whether the information requested relates to emissions into the environment. Now, that is clearly less restrictive than the directive. The directive goes further than Aarhus in seeking to define and limit the circumstances in which a request for disclosure may be refused, and in our submission, Aarhus therefore adds nothing to the interpretation of the directive and the regulations.
Does the expression interpreted in a restrictive way in this and in the directive really mean applied in a restrictive way.
No, we submit it means interpreted in a restrictive way, that you, when you're looking at what is meant by national security, you take a narrow view. Otherwise, we'd have to accept that all three legislators had got it wrong in their language. But the key point is interpreted in the restrictive way, taking into account the public interest served by disclosure. In my submission, what that's really getting at is the no class claims point. It's making it clear that you cannot have a class immunity point.
I didn't quite grasp that answer. Can you just go over that point again?
Yes, the question, my Lord Collins asked me the question whether the phrase, the aforementioned grounds of usual shall be interpreted in a restrictive way, meant shall be applied in a restrictive way. And I said, no, I didn't think it could mean that, because if it did mean that, it would mean that all the legislative instruments were using the wrong word, and that we must take it at its face value as meaning.
Doesn't it perhaps mean both? After all, it goes on to say, taking into account for the particular case, the public interest served by disclosure, that's an application point. And, I was just looking at Sweden and Turco, which has some resonance with this case, and I see that they say, in view of the objectives pursued by regulation, in that case 1049/2001, those exceptions must be interpreted and applied strictly. See another well-known case, Sweden and Commission. So it's interpreted and applied.
We would certainly accept that that's the right approach.
Yeah.
Certainly. But that, again, doesn't address the point in this case.
Well, it might do, in the sense that the basic European approach to exceptions is perhaps slightly more aggressive than our domestic approach, in the sense that we tend to say, well, exception must mean something, and you give it its normal meaning. The general European approach is to be pretty tight about the interpretation of any exception.
I accept that, and I accept that that's particularly an appropriate approach in the context of this legislative scheme. But what I also submit is that it simply doesn't follow from that where you have found, as a fact, that more than one exception applies, interpreting the exception strictly, that there is a real adverse effect and that the exceptions apply, that when you've found that you can't then consider together and balance the public interest on both sides. And indeed, in my submission, what one gets from the legislative scheme is emphasis repeatedly on the need to consider the particular facts of the individual case, the interests that are actually engaged, and the need to balance the competing interests.
So this is your point about class claims?
Yes.
Repeated reference to the particular case.
Yes, very much so.
It's not enough to say, just because this is about a particular sort of information, we're going to put a stamp mark to it.
Restrictive interpretation, facts of the case, all circumstances taken into account. We say, and all of that is entirely consistent with our approach. Can I deal with the Bovis case?
Yes.
In volume 2.
We're at tab 18, I think.
Yes, it is. And it's particularly paragraph 52. And essentially, the question that they are raising is the question that was raised this morning. If one engaged exception doesn't outweigh the public interest, how do two or more considered together outweigh the public interest? And the court has my submissions on that point. That the answer is simply that they can. Because if different aspects of the public interest are adversely affected by disclosure of a particular piece of information, those different aspects considered together may outweigh the constant, which is the public interest in favour of disclosure. There's some oddities in this paragraph. With respect to them, it's not perhaps as clear as it might be. They say that the statutory question directs us in figurative language to make a judgment on relative importance. But what, with respect, they are not looking at is the fact that if different aspects of the public interest are negatively impacted by the disclosure of a document, that in itself is something that needs to be taken into account. They say it's not a mechanical or mathematical exercise, and I would agree. And then they make the point that we've already discussed, and offer some more guidance. But
Would you say that the suggested difficulties in looking at the various aspects of the public interest in not disclosing is no more different or difficult than looking at the various aspects together of disclosing?
yes, my lord. And I, with respect to the
You're doing the
tribunal,
same exercise.
it's the same
on
exercise
both sides.
on both sides of the equation. I mean, with respect to the tribunal, I'm slightly surprised they find it so difficult, because this is the normal exercise that's conducted by all courts when trying to make this kind of judgment. So it's odd that this particular tribunal is finding it so difficult to deal with.
Oh, well.
I wonder whether they're making life difficult for themselves in the first sentence. The first sentence, I mean, it looks there as though they concluding that a particular exception is outweighed,
Yes.
negatived,
Yes.
almost it doesn't apply.
Yes.
That's going too far on your
Yes.
argument, I think. I mean,
Yes.
you can get it one way, yes, if it applies and is not overridden by the public interest, then you've got a ground for withholding the information for refusal, and that's good enough.
Yes.
But the case you're dealing with is one where you don't reach that position.
Yes.
It's engaged, but not fully satisfied, and it's that particular situation that is raised.
Yes.
And I have a feeling that they haven't appreciated that particular point here.
It may be so. It may be so.
I thought you were saying that the first stage was that you considered the public interest in relation to each exception separately.
Well, the way the Court of Appeal put it is that it would often be convenient to do so, and one can see why, because if you conclude
Yes, of course.
that one considered alone outweighs the public interest in disclosure, that's the end of the case. You don't
Yes.
need to go any further.
There's no point in going on.
There's no
That's
need
right.
to go on. no.
Yes.
But the situation is where you've got two exceptions engaged, neither considered alone outweighs the public interest in disclosure, doesn't necessarily follow that if you consider both public interest factors together, they won't outweigh the interest in favour. And with respect to tribunal, I don't see any particular difficulty in conducting that exercise.
What about the tribunal in this case, page 70 in the bound volume, in the appendix? Because this is a paragraph which is quoted by the Court of Appeal. It's paragraph 58, which everybody's come back to, and here's
Yes.
their objection to your argument.
Yes, it is. That's
and
right.
The last sort of 5 or 6 lines, I think,
Yes.
are, I think, suggesting that your argument leads you into some sort of general roving inquiry
Yes.
beyond the list of exceptions.
Yes, that
You've
was
already
never
said
our
that
case,
isn't right.
Lord.
Sorry, where are we?
This is page 70 and paragraph 58. It seems to us that for a
Yes.
fact to carry weight, it must be one that arises from the nature of the exception.
Yes.
You wouldn't disagree with that, I think.
Our argument, your Lordship can see the argument that we were making at paragraph 56.
Yes.
I said that you should consider all elements of public interest in favour of maintaining the exception, and this should include, 1, the public interest in respecting the commercial interests of intellectual property rights owners, 2, the risk to public safety, so that's the other exception that was engaged, and 3, disadvantages if the MNOs decide they should permanently withdraw their cooperation. So those were the only 3 aspects of the public interest I was suggesting should be considered. I wasn't suggesting that any other aspects of the public interest that didn't fall within the scope of the exceptions in Regulation 12.5 should be brought into play at all. And their conclusion was that they would take into account aspects 1 and 3, but they would not take into account aspect 2,
Yes.
even though they'd already found that was engaged. And what we, with respect, say is erroneous in this analysis is their claim at paragraph 58 that my submission would produce a strange result. We submit it's the alternative approach that produces the strange result, because it necessarily envisages a situation where the public interest is against disclosure, but you're bound to disclose.
But the last 4 or 5 lines, you would say, is really raising an issue which you weren't raising at all, which is something that might generally be said to justify withholding regardless of content. That's,
You're looking at the end of paragraph 58.
I am.
Yes, so the oddity there is, of course, it's the other side of the coin, that they had found that the public interest in withholding information that might be of value to criminals does not justify maintaining public safety exception. And then they're objecting to my point that you could look at intellectual property rights. But of course, that's only on the basis that the intellectual property rights exception is also engaged. Mm-hmm. It's the same point the other way round. And what we say is the oddity of a situation in which it's acknowledged by a tribunal that the public interest is adversely affected in the sense that disclosing this information will have an adverse effect on public safety, but they then ignore that factor when seeking to decide whether or not the material is to be disclosed.
Has there ever been a European case, apart from Sweden and Turco, on the application of exceptions under a disclosure regime in European law?
Well, not to my knowledge.
I mean, I don't know whether you looked at Sweden and Turco, but if you look at paragraphs 36 to 45, they're dealing with the exception of legal advice under the provisions for disclosure, and the provision for disclosure in the regulation has in it, like the present provision, a number of heads starting off with commercial interests of a natural or legal person, intellectual property rights, legal advice, court proceedings, purpose of inspections, investigations and audit. So there are a number of, unless there's an overriding public interest in disclosure. And what they say is that when you look at the legal advice exception, you have to conduct a three-stage analysis. You must satisfy yourself the document relates to legal advice. You must examine whether disclosure of parts of the document in question would undermine the protection of that advice. You must then, third and last, if you take the view that disclosure of a document would undermine the protection of the legal advice, it's incumbent on the Council, because that was talking about the Council Ministers, to ascertain whether there's any overriding public interest justifying disclosure. In this respect, it's for the Council to balance the particular interest to be protected by non-disclosure of the document concerned against inter alia the public interest in the document being made accessible in the light of the advantages stemming, as noted in the recitals, for increased openness, etc., etc.
Yes.
So, I mean, that's a pure
Yes.
exception-related three-stage criterion.
Yes.
It's preceded by the words that I read before. Those exceptions must be interpreted and applied strictly. See
Yes.
Sweden Commission, which spells that out in great length with a reference to a whole host of authorities. And there's no hint that you require to step back. And of course, in context, it didn't arise. But
No, it doesn't take one any further.
Europe tends to recite its previous decisions, and I just wonder whether your submissions aren't going rather well beyond what Europe has hitherto regarded as the appropriate and quite narrow approach to exceptions.
Well, we would submit that Europe has simply never considered this question about what you do when more than one exception is engaged,
Yes.
when more than one interest is engaged.
Yes.
And of course, the analysis that's there set out, would be an analysis that we entirely agree is appropriate if you were in a situation where a request only engaged one exception. Absolutely. And indeed, my learned friends have cited a number of information tribunal decisions which deal with that situation and that say the public interest that you've got to balance is the public interest that's relevant to the engaged exception. We don't quarrel with that, but it doesn't assist you at all in answering the question, what's the relevant public interest where there are two engaged exceptions? It takes us back to the question of the difference between the application of the exception and the conducting of the balancing exercise. Is there anything else?
Yes.
My lords, my lady, unless there are any further matters, those are my submissions.
Thank you very much indeed. Ms. Collier, do you want to follow? Thank you very much.
my lord and my lady, I can be relatively brief in reply. The ultimate question for this court is which of two models does the directive and the regulations contemplate being applied when dealing with these matters? In our submission, the basic position is there is a right to information and a duty to provide environmental information. A public authority is exempt from the duty to provide the information if one of a limited number of exceptions applies and the interest in maintaining that exception outweighs the public interest in disclosure. And in our submission, as Lord Justice Claw said in the Administrative Court, the focus of the legislation is on the particular interest which the particular exceptions serve, and it requires such interest to be specifically justified in a context where the presumption is in favour of disclosure. That's paragraph 40 on page 40 of the appendix. The alternative approach is not to focus on a regime where you have a right to access subject to limited defined exceptions, but instead to talk about assessing the overall public interest or the aggregate public interest, sometimes said to be looking at matters in the round, sometimes said to be looking at a situation where the two exceptions don't themselves justify non-disclosure, but you stand back in another metaphorical exercise and look at it. And
looking at it broadly, I hear it all the time.
My lady, I'm encouraging you not to be broad, I'm encouraging you to be narrow.
Focused.
Because the directive and the regulations do not proceed on the basis that there is some kind of abstract overall public interest, which is separate from, different in content from, and greater than the specified exceptions that you are dealing with. In our submission, if you look at the directive and then you look at how the regulations proceed, they approach it on the basis of a focus on the individual exception. Does it apply? Does the exception outweigh the public interest in disclosure? It does not approach it on the basis of a generalised, abstract, English type, wily, it's all part of the public interest. You start really with the recital at 16. The general rule is disclosure, and a public authority should only be permitted to refuse in a specific and clearly defined case. That is the starting point, Regulation 16. You then see the way in which that is translated into the directive, and it is done by a way of two provisions, Article 4.1 and 4.2, which set out sets of exceptions. There is no common underlying theme in the exceptions in 4 and 5, and no common underlying theme in exception 5. It is clear in response to my Lord Collins' question that interpret does mean interpret and apply, because you see that from recital 16. It says grounds for refusal should be interpreted in a restrictive way, whereby the public interest served by disclosure should be weighed against the interest served by the refusal. It is clearly both that they are talking about, because they are approaching it from the viewpoint of you can only avoid the right of access in a clear and defined case. And that involves looking at the exception, and when you're doing so in a way that is restrictive, weighing the exception against the interest in disclosure. And that is reflected in the language of Regulation 12 and 14. Regulation 12 is not the public interest. Regulation 12 is the public interest in maintaining the exception. That is what the regulation says. And you weigh that against the public interest in disclosure. Regulation 14 says you specify any exception relied upon. Again, a focus on individual exceptions. You don't specify one, and then maybe you'll toss in a few others should it go to the information tribunal. The focus is on identifying the exceptions upon which you rely, and then obviously you have to weigh that against the public interest in disclosure. Regulation 15.1 and 17 do not assist the respondent. They, if anything, assist the appellant. If I could ask you to look at 15.1, it is replete with the approach that we suggest is adopted. Does an exception apply? Does it outweigh the interest in disclosure? 15.1a would adversely affect national security. That is in effect 5a. you can refuse to disclose as a public authority if disclosure would adversely affect national security. B is in fact not the public interest full stop, it is the public interest under Regulation 12(1)(b). What is that? It is the public interest in maintaining the exception. That is the exception of national security in Regulation 12(5)(b).
There's something wrong with 15.1, isn't there?
As a matter of principle, by law,
No, in the
or wording?
text.
The text.
A Minister of the Crown may certify that a refusal to disclose information under Regulation 12(1) is because the disclosure would. Doesn't make sense.
No, I think they mean that the Minister says, that's why, and then you'll see the effect of them saying that.
Is what? A refusal to disclose information under Regulation 12(1) is...
It's his statement that it would adversely affect national security. And
I see, is because it would.
Yes.
I see. Yes, I see.
Did that deal with your Lordship's point?
Yes, I see.
The reason for refusal was that.
Yes.
Oh yes, you could put more words in, but it's clear what they mean. I don't think they're actually grammatically incorrect. But the point is, it doesn't assist my friend to say that this shows there's an overall public interest, because what it shows is there is the question of applicability of an exception. Would it adversely affect national security? And then there's the question of would it be in the public interest under Regulation 12(1)(b). That's shorthand for the public interest in maintaining the exception. It's the same with Regulation 17. If you look at 17.3 and 3A, it is exactly what we say the directive focuses on. The specific exception, if it applies, and does it outweigh disclosure. 17.3, if the appropriate record authority decides that such an exception applies. Always the first question, does an exception apply? And then subject to that, a determination on whether it may be in the public interest to refuse to disclose that information under Regulation 12(1)(b), because the public interest is maintaining the exception, not some kind of abstract entity that stalks the land untethered. My Lord, in terms of, and that is the short answer to this case, in fact, is that the whole of the European regime, as reflected in the regulations, does, as Lord Justice Law says at paragraph 48, and again at paragraph 53, if your Lordship's and Ladyship looks at page 40 and 41, 48, so the focus of the legislation is on the particular interests which the particular exceptions serve. It requires such interests in effect to be specifically justified in a context where the presumption is in favour of disclosure. Miss Rose refined her submissions there to say it's only the interest in Regulation 12, and then 50, in my judgment this position remains too wide. I've concluded that the scheme is that each exception must carry its own justification. And then he goes on to Regulation 12(1)(b), the contrasted 13 of the regs, which talks about the public interest in withholding the information rather than maintaining the exception. And again at 53, the reason that I think the approach taken in that textbook, which is the approach we adopt, is correct, is essentially grounded in the policy balance that one finds in the directive and in the regulations. There is a general duty to disclose. It is, as Mr. Chowdhury put it, purpose blind. No justification has to be shown for the disclosure in the first instance. The exceptions are drawn tightly. The wording suggests at least that they must be considered exception by exception. And that includes the public interest that attaches to each exception. The scheme is a striking one, but it seems to me that the words, both of the directive and of the environmental information regulations, promote the result that was arrived at by the tribunal. And then one final point, my Lord, about paragraph 12(5)(a. Is it one exception or is it four? We have always said, and it was common ground below, and if your Lordships go to page 17 of the appendix, paragraph 38, there are four exceptions in paragraph 5A.
Sorry,
not
17,
one.
appendix 17, where?
Of the appendix, my Lord. Yeah. It's the judgment of the Court of Appeal.
Yes, right, yes.
It's the most convenient place to get the common ground. Does your Lordship see it there? That description.
Can you give me the reference again?
Page 17 of the appendix, paragraph 38 of the Court of Appeal.
Yes, I'm with you, thank you.
That construction is reinforced by the number and nature of possible exceptions. For example, it is common ground that paragraph 5A of Regulation 12 is to be read not as a single exception, but as containing four separate exceptions. In fact, we say the nature of the exception points against aggregation. Paragraph 4 and paragraph 5 are different in nature and quality. Within paragraph 5, there are different types of interests, as my Lord Mance pointed out. Some are public interests, some are private. Your Lordships will recollect that the directive doesn't even use the word public interest in refusal. It talks about the interest, so it's not presupposing some public interest in the abstract sense. And again, the number of exceptions goes neither here nor there. So that, my lords, those, my lords, are our submissions. Nothing else. Those are our submissions in reply, unless we could assist your lordship further.
Well, thank you very much indeed, Mr. Lewis. It is, as you were indicating in the end, a very short point, but the court is extremely grateful to counsel for their assistance orally today, and also the cases in writing, which we've read carefully and will take away with us. Will be no alter for costs. I think, Ms. Rose, you agree.
That's right.
That aside, the court will consider its decision. It will be issued in due course.